Section 60 of the original Act has been amended, which has given greater concessions to the judgment debtor from arrest and from attachment of his salary. That will relieve some hardships. The Law Commission, in its two reports, have recommended the deletion of this section. The bill as originally introduced also deleted that section, but that the committee in its wisdom found that the notice should be there so that cases which are genuine might be settled out of court by the government so that unnecessary expenditure need not be incurred by the litigant and also the litigant not undergo unnecessary expenses and worry. But this section which is being restored should not be understood in favor of the government, but the government should deem it a duty to see that whenever a notice under section 80 is received, it should examine the claim of the aggrieved citizen and see that it is settled or it is genuine so that litigation could be avoided. Otherwise, the government or the government officers never bothered to look into the notice. The litigant is at a loss and he has to go to the court. The purpose was not being served. Now, I hope with this amendment, the litigant will not be driven to the court to file a suit. In cases of course where the government feel that the claim is genuine, it could be settled and avoid the litigant from going to the court. About section 100, which speaks of second appeals, they have introduced the words substantial question of law. The wording earlier was on a question of law, a second appeal, lie. That is the wording under the existing section 100 of Civil Procedure Code. But they have now put the words on a substantial question of law. A substantial question of law should be involved for a second appeal. What does it mean? Suppose the decision of a suit depends on a question of limitation where the plaintiff files a suit and the defendant contests the suit as barred by time. Is it a substantial question of law or is it only a technical question of law? If the latter is upheld, the appeal fails. Therefore, I cannot understand why on a substantial question of law have been introduced in section 100. I think really it is taken out of the Constitution where it is stated that substantial question of law involving the interpretation of the Constitution. I believe that any question of law which has the effect of deciding the result of the case should be considered as a substantial question of law. Sir, section 115 of the Code of Civil Procedure has been amended so as to take away the power of revision of the High Courts against questioning orders. This revision was causing a lot of inconvenience to the litigant against questioning orders filed in courts which are pending for years and the suits are being stayed. This has been taken out. Of course, the power of revision of the High Courts is there where no appeal lies. I fully endorse this amendment clause. About judgment, a new clause has been introduced. The judgments should be delivered within a fortnight of the closing of the hearing of the case. If that is not possible with notice to the parties, it should be done within 30 days. This is very salutary. If the court finds that it is not possible to deliver the judgment within 30 days for reasons to be recorded in writing, it can postpone the delivery of the judgment to a subsequent date, giving notice to the parties. Therefore, the purpose of the amendment would not be served ordinarily in cases where the judge has to give notice to parties of judgment at a later date, and I do not think the litigant will be benefited. I am glad that another new order has been added which gives the party, the litigant, the costs incurred by him prior to the filing of the suit. It is a good thing. Previously, the plaintiff who obtained a decree could not get the costs incurred by him prior to the filing of the suit. Now, this has been included. It is a good improvement. Under this provision, in such family suits, the courts shall try to settle them before the trial begins. It is a good thing in family matters like a husband filing a suit for judicial separation or the wife filing a suit for maintenance. There, the courts will come to the aid of the parties, and in camera, they could try to settle and see that they could come together. In most cases, the courts will succeed in seeing that parties come to an understanding without undergoing the trouble of lending evidence on other side. Similar provision should be made where the subject matter of the suit does not exceed rupees 3000. We have limited the right of appeal of suits where the subject matter is more than rupees 3000. Sir, similar provision should be thought of here also so that the court would come to the rescue of the persons and see that the matter is settled. Now the position is that assistance of lawyer would be given to the plaintiff. The High Court is authorized to frame rules as it deems fit, but God alone knows when the High Court will frame such rules. Legal aid should not be taken as only an assistance of a lawyer. Now you are giving assistance of only lawyer to plaintiff who is needy. But what about defendant who is also equally poor? I am not talking about poor defendants. He is equally needy and he should be entitled to legal assistance. This, of course, comes within the purview of legal aid. There is also another proposal in the amending bill that case which has been brought should be disposed of within 60 days. Under the election law, election petitions are required to be disposed of within 6 months, but they are never disposed of within 6 months over.